Please keep eating and go back for more, and jurors particularly go back for more, because I know the food's better here than you got during your jury service. Based upon your responses to our short questionnaires, one of the reasons we begin like this promptly while you're still eating, so you keep going, because we want to end these, we promise everyone we'll end these programs sharply at 1:30, so the judges can go back to judging, the trial lawyers can go back to trying their cases if they need to be tried, and the jurors can enjoy themselves too. On behalf of the sponsoring organizations whose names are displayed on the screen and the host law firms, welcome to Columbus's first Jury Improvement Lunch. This is the 14th such lunch we've had across the country. We had one yesterday in Cleveland and on Monday of this week in Baltimore. And as we continue moving across the country with these lunches, they just get better. The Civil Jury Project, of which I am the executive director, was established 3 years ago as a 5-year project at NYU School of Law. It's the only academic project going on in the country that is exclusively dedicated to studying why the jury trial was so important to our founding fathers that it is mentioned in 5 of our founding documents: the Declaration of Independence, Article 3 of the Constitution, and 3 of the Bill of Rights. The jury is so much a part of the DNA of the American justice system that there is not a courtroom in this country that doesn't contain a jury box. Yet, unfortunately, as this slide demonstrates, those jury boxes today are largely unused. Since 1962, the number of jury trials conducted per average authorized federal judgeship across the country has dropped from 10 to 2. Note on this graph that the blue line shows the number of bench trials, and that line has dropped even more precipitously than the number of jury trials. Probably that's a dramatic proof that the disappearance of jury trials is not due to some special characteristic of jury trials. Either their expense, or their length, or the fear of runaway verdicts, or the requirement of some specialized jury advocacy experience. If those were a factor, you would not expect bench trials to have dropped faster than jury trials. Something else is going on. The next slide shows that here in the Southern District of Ohio in federal court, the slides look very similar. Beginning in 1997, the average judge here tried last year in 2017, the average judge in the Southern District of Ohio tried only 1.25 jury trials and 0.38 of 1% bench trials, less than 1 bench trial per judge. Clearly meaning that we have a lot of judges that have not tried jury trials or bench trials in the last year. One might explain these dramatic drops by the fact that the number of cases being filed in courts has dramatically changed, but the next slide accounts for that. It shows the percentage of civil terminations. This is a percentage, so it should be unaffected by the absolute number of cases filed. The percentage of the cases filed which were terminated by bench and jury trials has dropped too dramatically, so that now less than 1% of all cases filed in federal court and across the country get tried by a jury. And so some people say, well, how about the state courts? What we have found in going around the country is state courts, same graph. This is the percentage of civil cases disposed of by jury trial in the state of Ohio and in Franklin County in the state courts. And you will see, this is only jury trials, not bench trials, but again, you will see what has happened since 1999. Dramatic, if this does not show that trials are in danger, all trials are in danger of being extinct, and nothing will. The Civil Jury Project is studying why trials are vanishing, whether this should be a cause of concern for those involved in the justice system, and if so, what can be done to either stop or reverse the trend. I am the executive director. Anna Offit, who's standing back there, is one of our research fellows. Thank you for coming from New York to help us do this, Anna. And let me briefly mention what we have accomplished at the Civil Jury Project. We do things other than arrange these lunches, which are pretty time consuming. It's like arranging weddings or bar mitzvahs. I mean, you have to rent a hall, you have to get the judges to cooperate, you have to get the bar organizations to help sponsor it, and then try to get the law firms to turn out their trial lawyers to come. We have created at the Civil Jury Project 2 distinct websites. This one's designed for judges and lawyers, and in particularly our judicial advisors. We began this project by going across the country and meeting with state and federal judges to try to interest them in helping us revive jury trials. And we now have 250 judicial advisors across the country, both state and federal, that we regularly communicate with and we seek their advice on and the exchange of ideas. We also have over 60 academic advisors, virtually every law professor in the country who has done research in jury trials or written about the history of jury trials is an academic advisor. And in an unusual kind of collaboration, we are working with the American Society of Trial Consultants. We have 30 jury consultant advisors that help us test whether some of the things we are suggesting work or do not. We have dozens of projects going on. They're listed on our website. I'll just mention a few. We do a lot of empirical research. We took a survey of non-lawyers recently, over several thousand non-lawyers, and what we found to our great surprise is that 80% of the people surveyed who are not lawyers think that in the last 10 years the number of trials, jury and all trials, has grown significantly. When we tell them they're dead wrong and show them these graphs, they are shocked. And they also, when we tell them that the jury trial was a right mentioned in 5 of the founding documents and guaranteed in 4 of them, they say they get very concerned about the fact that we are losing jury trials. So we lawyers and judges, we want to save jury trials. We have a big public education program to do it. It is not well known that most of the courtrooms of this country are dark during the week. That you can go to the federal courthouse in any city in this country and shoot a cannon through the hall on a weekday and not hit anyone. Yeah, maybe justice is being delivered, maybe disputes are being decided, but it's not during the course of public trials. We also studied last year all material contracts. Big companies, publicly held companies, have to file their material contracts with the SEC. So we went and looked through 5,000 of those contracts publicly available to find out how many of them have jury waiver clauses or arbitration clauses, meaning the parties to those contracts, usually other businesses. These are not contracts of adhesion, consumer contracts, big contracts that are material. We found that only 43% of those contracts contain jury waiver or arbitration clauses, meaning that in spite of these declines, probably the majority of corporations or corporate in-house counsel still believe that jury trials are a good way to resolve disputes with their co-equals, business disputes. And then we went about calling these people to find out, well, what did they think really about? Was this an accident or was it intentional that they did not waive jury trials or insist upon arbitration. And again, to our surprise, many talked to us and many told us, including the guy who was the general counsel of Exxon for the last decade, that they have lost faith in arbitration completely. It's just as expensive as a jury trial. There's no right of appeal. It takes longer usually because arbitrators paid $750 an hour are under no incentive to dispose of cases quickly, and that they are now happy to come have their case resolved by jury trials. I mean, I think that's becoming a more prevalent opinion, and again, we intend to publicize that to the frequent users of dispute resolution services. We have been active on social media. We conduct programs like this for judges, for lawyers around the country. We have put on 3 all-day workshops at NYU for state and federal judges. We have 30 judges at a time coming from all over the country, spending a full day on a program that deals with jury trials. It's in 4 sections. Section 1 is selection of juries. What can we do to make the selection process better, more comfortable to jurors, more likely to disclose undisclosed or hidden biases? The second program is care and feeding of jurors. What can we do to make sure that jurors do have the right snacks, are paid properly, get good parking, have instructions given to them in plain English, have questions answered by judges when they are asked by the jurors during deliberations. A third section is what can we do to improve the trial itself, the jurors' comprehension. Is it weak in this country? I don't know exactly how we got here, but we have not typically given jurors the same tools to make decisions that we give to judges or arbitrators. Some courts, they can't take notes. Some courts, they can't ask questions. The instructions are given to them at the end of the case rather than the beginning of the case. They can't discuss the evidence while they're going. They have to wait till final deliberations. And on and on and on. There are many things that we do to make it more difficult for jurors to comprehend and get the right result than we do for judges working with their law clerks or arbitrators working with 2 other judges. Is there any wonder that maybe some people think they get a better shot with dispute resolution other than by trial by jury? And our final section of those all-day workshops, and we're planning 2 more, 30 judges apiece in October. The final section is how do we train the young advocate? That has been a very vigorous program, and thanks to what we are doing around the country and promoting, it is a subject that is being discussed. Some of you here today are young advocates. Thank you for coming because you need to hear what's being said. We have encouraged judges around the country to adopt young lawyer rules, which is simply where the judge announces that if you will let me know that a young lawyer is going to argue a motion, I will give you an oral argument when I normally would not give an oral argument on that motion. And some judges have even extended this to trial now. If you will let me know that a young lawyer is going to play the role of lead counsel by giving the opening statement or the closing statement or cross-examining witnesses, important witnesses, I will give your case priority over other cases. All these things are great. It will improve our education of young lawyers, and it will also improve the diversity of the trial bench, because what happens so often is that diverse lawyers are writing the briefs, but white males are making the argument. And we need to really change that. And the way to change it is by some of these special efforts made by the bench to get a diverse spokesman for clients on their feet. As I said, this is our 14th jury improvement lunch. We have scheduled already for next fall in Boise, Miami, Oklahoma City, Los Angeles, Tucson, and Las Vegas. Houston in May is having its 4th jury improvement lunch. Dallas is having its 3rd. The whole notion here is we will send to you a monkey survey when we're done today. We ask you to take the time to fill it out. We provide it to the sponsoring organization. We provide you all the results of the survey so you'll all know what everyone else thought. But the notion is, if there's a sense here that this is worthwhile and we should do it again, then we will help you. The Civil Jury Project will help. But the beginning impetus for the program will have to begin locally. And people will repeat it if they want to. We have published a newsletter monthly for the last 16 months. They're all on our website. You who now have given us your email addresses will become on our mailing list for those things. One of the things we are doing that is quite interesting is we have a second website. This is only for jurors. We the People, WeTheJury.com. The civil jury is in decline. And there, as you see at the bottom, there are 3 portals. The one served jury duty before. Now we get people to go to this site by asking judges around the country to give to the jurors a card when they discharge jurors. It looks like this. It's a business card. It says, make your voice heard. If you want to talk about your experience, go to this website. When they get to the website and hit that little icon over there, they are given a questionnaire. We get hundreds of jurors who are discharged jurors coming to this website and each week and filling out, served on jury duty before, and filling out a questionnaire talking about their experiences. If they're interesting and want to give us their phone numbers, we contact them. And we go send a videographer out to get testimonials from those jurors about their experience. This went over, if you go down the middle of currently serving on jury, they immediately see a warning that says you shouldn't be here. The judge told you not to be here. Come back when your service is done. And if you go to the left, which is where we get hundreds, literally hundreds of clicks, we count how many come there. Those people who go there find us by our social media, Twitter and Facebook presence, which is this one right here. And we post on this all the time. And they come looking for ways to get out of jury duty. And when they click on that icon on the opening page, they will see prominent judges, prominent Jeff Bezos, Senator Whitehouse, and others talking about the importance of jury trial, and a lot of jurors, former jurors like the one you're going to hear on the panel today, saying, don't throw your summons away, go do it, it's the best experience you could ever have. And so hopefully we are going to improve the yield of jury summons by doing this. Now, we just got the good news, our Civil Jury Project did earlier this week, that NYU, the law school, has decided to make the Civil Jury Project a permanent center without a 5-year life on it. And so it will continue because of the work we've been doing. We need to focus on how to improve jury trials so that they are affordable and perceived to be reliable. Because we all know that there are alternative ways of resolving disputes privately, but there's no alternative way of exposing ordinary citizens to how the legal system works or empowering them to play an important role as decision makers. Now, I would like the following. First place, we have with us a group of prominent judges and jurors today. So I would like first for Judge Sargas, the Chief Judge of the Southern District, to come say a few remarks, and will be followed by Judge Fry.
Well, good afternoon. It's nice to see everyone. Thank you for being here on a sunny Friday afternoon, one of the first in Ohio this year. I want to start by saying our court is very supportive of Steve's efforts. We may have a little bit of a different view of some of the issues, but the fundamental point about the disappearing jury trial is something that none of us can deny, because this is something we can just look at hard numbers. Before I get to that, I do want to mention we have Judge Sutton here. He's worked very hard on rules that would make jury trials probably more affordable. We've always supported him in that regard. I do want to mention, it's possible in my remarks there could be error, but at most it would be harmless error. So just be clear on that. It's nice to have you here. Judge Jolson is here from our court. Judge Martley would be here, but he's trying one of those disappearing jury trials right now. So if we look at raw numbers, and I want to just go back for a moment to what has just been mentioned, there's no question that trials have really skinned down. If we look at national figures in the federal court system, and the hardest number has to do with criminal cases, because there's no explanation needed when we look at percentages. But about 2.8% of cases indicted actually go to trial. So very low number. That means roughly 97% are either dismissed, which is a very small number, or there's a guilty plea. The civil numbers are a little bit misleading. 0.9 of 1% of the cases filed go to trial, but the first number we want to consider is about 55% of the cases filed in federal court do not have a right to a trial by jury. Those would be everything from Social Security appeals to habeas corpus petitions. But I would say if you back those cases out, we're still looking at 2 to 3% of the cases go to trial. So of those where there would be a right to a trial by jury. So the numbers are still very small. My personal experience has been pretty similar. I've been on the bench for almost exactly 22 years, and I've tried exactly 88 cases. The math is helpful, there are no fractions here. 88 divided by 22, I average 4 jury trials a year. And in terms of our district, it depends on what month you pick, but the numbers that I have are a little bit different. I did talk to our jury commissioner this morning, so these are hard numbers. In 2007 in Columbus, there were 11 jury trials, 7 criminal, 4 civil. 2016, there were a lot more, there were 16. These are small numbers, so they tend to be different from year to year. But again, the average is about 4 per year. One of the things that makes it seem as though there are not as few jury trials as there used to be is that the length of jury trials has gone up. And that has a couple of bad consequences. It means jury trials tend to be more expensive, and the blunt word from litigants usually is if it's going to take a few $100,000 to try a case, and the case has $50,000 at play, the math doesn't work. So my view is a lot of the reason we're seeing this is the cost of litigation has gone up, and there's sort of a reinforcing downward spiral as cases become fewer in number. They become more expensive because the lawyers are not as familiar with the courts, not as familiar with each other, and the more the expense goes up, the fewer cases have any appeal to try. We certainly are not opposed to, our court has a very active mediation program. I'm not at all inclined to dissuade anyone from that. There are many good reasons to settle cases. Sometimes it's simply in the mutual interest of the parties. Sometimes it's cost savings. Oftentimes parties have ongoing relationships where a settlement sort of reduces the tension and allows for future harmony. Those are the good reasons. The bad reasons are multitudinous. If people feel compelled, I don't think we have anybody in the Columbus bench that forces people to settle, but I know from my 15 years in the private practice, I certainly had that experience more than once, where clients felt very bruised and pushed and cajoled. My view is that people have a lot of reasons to settle. That should not be one of them. But again, I think we have seen, in my view, as discovery has really exploded in the last years that I've practiced, going way back to the late 70s, that with that has become a decline in jury trials. I think a lot of the expense things that drive cases now have just simply made jury trials unaffordable. And I do think that we have a challenge, particularly in the federal courts, to figure out ways to make discovery more affordable, make trials more affordable. The two go hand in hand. But with that being said, all the fundamental points Steve just made, I completely agree with, and I think it's a great opportunity for all of us to think about different approaches to jury trials and how we can make the system better, with that option always being there for parties who wish to go to a jury trial. That is a critically important fundamental right we have as Americans, and we don't want to do anything that would lessen that. I also want to mention that we have 2 real judges here, at least 2, I may be missing a couple, Judge McIntosh and Judge Fry. My wife used to always kid that she could do any type of case known to the legal system except a quo warranto action, but you 2 both knew that. That's reserved for the Court of Appeals. Everything else a Court of Appeals judge can handle. Unlike federal judges, they never have to sit back and ask, do we have jurisdiction or we don't? They always have it. So it's nice to be with them as well. And Steve, thank you for putting this together.
Thank you. And we also have here, bad boy, because I should have introduced the other judges. We have here Judge Blunt, Laurel Blunt from the state court. Judge Blunt, are you here? I think she's here. We have Judge Thompson and Judge Woods. And I think I got them all now. But Judge Fry, would you come forward and say a few things?
On behalf of my colleagues, I wanted to thank all the jurors who took time out of their schedule to come down today to help us to address this important subject. As we say when we orient jurors on Monday mornings, we can't run the courthouse without you. Not only do you sit and decide cases for us, but more often you focus the mind of the lawyers and of the litigants and figure out, or they figure out that they have some bright people downstairs who are going to be brought up and who are going to decide their case that day or that week, and their case is going to be resolved by folks who the sarcastic would say are too dumb to get out of jury service, but the rest of us know who are very smart and who have life experience and the focus and the good intentions to do a good job helping run the justice system. I want to acknowledge, again, on behalf of my colleagues, the sponsorship of the Columbus Bar Association, of ABOTA, the Federal Bar's Columbus chapter, and NYU Law School, and plus several of the finest law firms in the city that help sponsor this thing. The message of NYU has been heard, I think, as Steve has said, around the country, but I want to assure Steve, because we haven't talked about this, that it's been heard in our county jail. So far this year, I've had 6 felons ask for jury trials. And one of them even commented after he got the verdict that this wasn't at all like television. So you're having an impact in places you probably didn't think of. But we do get an awful lot of criminal trials in the state courts. That diminishes our ability to hear civil cases, much to our chagrin, particularly those of us that tried civil cases when we were in practice. But we have a visiting judge regularly with us. Judge Dan Hogan was there last 2 weeks and tried a medical malpractice case for 7 days. So we have that opportunity available, plus we have 9 very fine magistrates who try cases, including one who gets an awful lot of our medical negligence cases and tries those with juries. So there are ways that you can get trials in Franklin County even if you're not in our jail. The observation in the early 1800s by Alexis de Tocqueville in Democracy in America bears repeating. The jury, which is the most energetic means of making the people rule, is also the most efficacious means of teaching it how to rule well. Every week we see people who do a trial and then talk to us after the verdict comes in, and they talk about how they didn't really understand what the law was or what the court system did or what judges did, and they have taken away from the experience of 3 or 4 or 5 days as jurors opportunities to understand much more about the democracy and about the role that individuals can play and the importance that they have. And that really reinforces for them and their families, and hopefully for a broader circle around each one of those jurors, the democracy that we treasure and that we claim to have in this country. And hopefully we can keep not only using what we have now, but enhance the ability of the courts to use more jurors and try more cases. Disinterested and wise jurors who bring the collective intellect of a group of folks can really settle controversies between citizens and between the government and citizens in a much more satisfactory way than if it's just an elected or unelected judge who makes a decision. The jurors also learn, obviously, at least a lot in our court, about parts of the town that they don't know anything about, whether it's medical negligence issues or whether it's drug issues and what kind of firearms are on the street, or how modern business is conducted or is not conducted well. So that there's a broad educational feature to having jury trials, and it really is an institution that needs to be continually protected and enhanced if we can do it. So thank you all on behalf of my colleagues for being here today.
Now I'd like our jurors to come forward. Ms. Hartley, and take your place up front. Ms. Hudson, Mr. Kelly, Mr. Lightfoot, Mr. Myers, Mr. Schnack. And we also have a juror who's not going to be on the panel, but came in like Mr. Morris. Would you stand up and be recognized? I know he's here. Thank you for coming. I'm going to moderate and ask some questions, but let's...
I just know we have one more juror here, Keisha, who also is joining us, so welcome.
Thank you. You introduce yourself. Thanks for coming. So, these jurors, let me read you something that I got an email from a juror here. Here's what it said. She's not here. I think the fact that you go to this measure to thank jurors and request their feedback says so much about Columbus's civil service system. So thank you. This was such an incredible experience for me, my second call to duty, and the first time I sat on a trial. I truly do believe that this is something that everyone should be part of. Seeing the civil criminal justice system at work in real life, as opposed to television shows and often sensationalized or selective media, show what it really looks like. Often it's mundane. Sometimes it's quick, and other times not. But getting to see it for what it really is, and that everyone has the opportunity to have their day in court, demonstrates some of the most important rights we have as Americans. And then she goes on for a few paragraphs. She said, my only little criticism was a lack of vacant snack foods, the Wi-Fi was down, and the parking was exorbitantly expensive. But she says, on the positives, I honestly felt like royalty the week and a half I served. I know that everyone was so dedicated to us to ensure that we did our jobs with as much reverence as intention as possible. And I can't say enough about how impressed I was. So that's quite a testament to what is going on here in Columbus. By the way, this program is being videotaped. The videotape will be up on our website next week. You can download it if you want to show it to anyone, any public schools or college classes, or anyone who want to see this discussion with jurors. It's available, as are the other 13 civil juries. We always have you tape because who knows when something brilliant is going to be said by one of our panelists. Now the thing about our panelists today is we have two at the end here who served on federal juries, both civil cases. We have one who served on a criminal case. Who was that? A state case. And the other three served on state civil cases. The thing that they all have in common is that none of the cases lasted more than 3 days. Am I right? All 3 days. So, Judge Sargis, I'm not sure your criticism was totally fair about...
Well, you missed a federal juror. Ask her how long her trial was.
Longer trial. Okay.
6 weeks.
It may be in different cases, but these are largely civil cases and they're largely quick. There are some obviously extended cases. So let me begin with this question to you. Well, I'll begin with a question that I asked. I was at the TED conference last week in Vancouver, and we had a dinner, a Jeffersonian dinner, where we talked about, here was the question: if you were sued for more money than you had, would you want the case to go before a judge, a jury, or an arbitrator? It's hard. You want a jury trial? If you're sued, or you're accused for crime, it doesn't make any difference.
Yes.
Either your life or your liberty or your property is at stake.
I would want a jury trial, especially since I served on a jury and I know what it's like.
Ms. Hudson?
Jury.
Mr. Kelly?
I would say a jury. Again, depending on the circumstances, what I
Yeah.
did, what I didn't do, what I didn't do.
And I bet one of the circumstances is a lot of people want to say, well, if I only before Judge Fry. I don't want him to decide my case, but you don't have that choice. There are multiple judges in most metropolitan areas, and you don't know what judge you're going to get when you walk in the courtroom. And some are good and some Well, maybe not so good, but they're different. So, go ahead, Mr. Lightfoot.
I would say jury.
Mr. Myers.
Jury, sir.
Mr. Schneider.
Jury.
So, we have all fans here, that's great. Now, my next question, when you first got the summons to jury service, did any of you go to the internet to try to figure out what this was about? No one did. When you then go to the courthouse, when you arrive at the courthouse, how long did you stay in the jury assembly room before you went to a courtroom for the voir dire, the voir dire process, where the questions are asked? Mr. Schnack, how long were you there?
2 days.
2 days before you even left that big room?
Yeah.
Okay, that's a
Oh,
long.
no, I'm sorry. It was the second day we got called.
So the first day you sat in the room. What went on in that room? Were you bored?
I had my laptop, I had a book, there was a movie playing.
Was the Wi-Fi okay?
If I recall, yeah, Wi-Fi was fine.
And what movie were they playing?
No, I didn't watch.
No, seriously, I asked this question because I was summoned for jury duty a year ago. I've never been selected. And I went down to the Harris County, I'm from Houston, I went to the Harris County jury assembly room, and they had a big screen at the front, but all they had on going was these soap operas during the day. You know, like As the World Turns. And it occurred to me that one of the things we could do as Civil Jury Project to make life more interesting is put together a professionally done movie that lasts about 3 or 4 hours of either clips from major jury trials, you know, get the permission of the producers of those to use My Cousin Benny, and some of the best things happen in jury trials. Even to commission the making of a documentary about jury trials. A lot of these things are, 90% of the jury trials in this country go on in state court. About 80% of the judges in state court are elected. They have a self-interest in appearing before 300 or 400 people in the jury assembly room in the morning and welcoming everyone. I mean, they're voters. But judges are not very good at interesting people, and some are, but that's not their forte. So we thought about making something that would, how would you think about that, Mr. Myers?
I think it's an excellent idea. I just think that part of the problem is that getting that diversity of, you know, range of trials and what have you, to do that. But I think it's an excellent idea.
Would be more, and it'd be educational. I mean, we have hundreds of citizens sitting around for a day, wasting their time. If we could give them something interesting to do. Okay, let me ask this. So they take you then down to the courtroom to begin jury selection. What were your thoughts about, and you've all been warned, because you've all filled out a form that says at the bottom of the form, just so everyone knows, as a reminder, we tell them this when we invite them, it's imperative that you do not discuss the facts of the case on which you serve or the specifics of your deliberations during today's events. Likewise, we ask that you do not reveal the names of the parties, attorneys, or judges. Thank you. So we'll follow that rule, and it's not, no one's particularly sensitive, but some of the cases may be ongoing, there may be an appeal, maybe some unhappy litigant or lawyer is looking to find some problem that went on in the jury room to have a post, verdict appeal. So I'm just telling you that, we don't want to talk about that today. The process is fine, how we improve the process. So you go around, the judges make some welcoming remarks to you. What was, Ms. Hartley, what was your impression of the remarks that the judge made to you?
I thought they were very interesting, and they actually helped me start to understand exactly what I was supposed to be doing while I was there.
Did you all feel welcome by the judge?
Oh, absolutely.
Very much so.
Usually we find that happy jurors are happy because they had a judge who was engaged and tried to make them happy. When the process, in your court, I don't know how it works in your court, but are the lawyers allowed to ask you questions during jury selection?
Yes.
The lawyers in federal court too, so the lawyers were asking questions. Did you think, did that bother anyone, that they were asking questions? You didn't think it was an interference or intrusion on your privacy?
Yeah.
Do you think that the lawyers who were in your case asked enough questions or the right questions to disclose? I'm not talking about your hidden biases, but the hidden biases of other jurors, fellow jurors. Do you think they got the ones that shouldn't be on, struck the ones that shouldn't have been there? Or do you think they missed Mr. Schnack?
Well, we never deliberated, so.
You don't know?
Yeah, I don't know, but I thought they asked, all their questions were appropriate.
Mr. Kelly?
Yeah, I was on 2 jury selections. I didn't get selected on the first one, but I did on the second one. It was interesting, both were civil trials, and both of them, they asked some of the same questions, so obviously there's a book out there somewhere. But I think so. I think they tried to, and you could tell they were looking at people's backgrounds to ask certain questions of specific people. So, yeah, I think they were doing the best they could at that point.
Okay, and it didn't land. Ms. Hudson, what was your opinion of the selection process?
I thought the questions were, helped them decide which jury to get rid of and which ones not to. They didn't, it was a volunteer thing, and so probably if they asked each person individually, they would have gotten more jurors, dismissed more jurors, because some jurors didn't say anything. So if you don't ask, you have no idea what.
You mean they addressed their questions to everyone who was there, not particular jurors?
Right. They would ask the question, and if you had that experience, you have to answer. If you wanted to, you didn't, they didn't just say, I'm going to ask each one of you.
Okay. So at the beginning of the trials you were in, did the judges give you any instructions about, see, one of the criticisms of jury service today, particularly in complicated cases or cases that go on for more than a few days, is that the judge doesn't tell the jurors what the law is and what the questions that they're going to be asked until the end of the evidence, which is kind of counter to what we do in life. You don't put a complicated piece of machinery together and then go read the instructions. You read the instructions first and then go try to decide. I take it in your cases you didn't get much guidance at the beginning of the case from the judge. Is that fair?
Correct.
Would it have helped you to have gotten more guidance? To say, hey, suppose the judge had said, at the end of the case, you're going to be asked these 3 questions. And actually put them up on the screen. I'm going to ask you these 3 questions at the end of the case. I'm going to tell you what you're looking for on each of these. Would that have helped for the judge to be more helpful in that way?
I think so.
All right, you're in. One of the things, about half the judges in the country now are allowing jurors to ask questions of witnesses. They do it typically in writing. How about in your case? Did the judge allow any questions of witnesses by the jury?
I think my judge would have allowed it. He said possibly. It depends on what the question is. I think.
But there was no procedure. He didn't give you instructions at the beginning. You can ask questions, you put them in writing, you hand them to the bailiff. That's it.
Yeah.
Okay. But you don't, you have liked the opportunity to ask questions.
Yes. Yes.
Yes. We're trying to encourage judges. It can be done. In almost every jurisdiction in the United States, it can be done. But we have to. Did the judge allow you to take notice?
Yes.
Yes.
You could all take notice?
Yes.
No.
No.
So
I would go back to the jury.
See, one of the problems with jury service that we're trying to convince these judges and lawyers that there's no real good justification for not giving jurors the same tools that the judge has in the case where he's hearing it as the fact finder. He's taking notes like crazy. And he's got the transcript up on his screen because he's getting daily, and he's getting it written as it is spoken. So in any event, when the ones that were allowed to take notes, were you allowed to take notes back into the jury room?
Yes.
Yes.
You could take it back.
Not We could until deliberation.
Until yeah.
Right, yes,
Right.
yes.
Did the judge told you, I'm sure you did it, okay, stay away from your electrical devices, electronic devices, no going on the web, don't try to Google anything about this case. That's improper. And that certainly is true, because you're supposed to decide the case on what you hear in the courtroom. Was that a hard instruction to follow? No. See, one of the things we were finding is this is very much a generational thing. Many of you are like almost my generation, not quite, but almost. But young people who are served on juries in their in their late teens and 20s, they are having a very difficult time staying away from where they should stay away. And that's an issue. But then when the problem, let me ask you this, I found out yesterday, this was interesting too. After the trial was over, some of the jurors would go and Google things that they heard during the trial, and actually learn things that they were surprised to learn, and they would have wanted to know during the trial. Did that happen to any of y'all?
Yeah.
It did. Michael, can you tell us about that?
Well, our case was unusual due to the fact that we all got called and individually talked to at the beginning because they were looking for something, we're not sure what they were looking for at that time. So after the case was over, I went in to see what they were actually looking for. And it was something that most likely shouldn't have known during the case. So, but I did go and look because I just, when you told me you're not allowed to do something, it almost perked their interest, like, I didn't I see.
So, during your cases, which 3 days is not for, I mean, there's some jurors that serve for 3 months. So, it's you were lucky that you did your city's duty in 3 days. But there are, so the judge tells you at the beginning of the case not to talk to each other about the case until you deliberate at the end, which again is something that's kind of, it's not a teaching method. I mean, students go hear a lecture, you go out of a lecture and say, that professor didn't make any sense to me. I never understood, why did he talk about this? Or that professor was great. Do you have expert witnesses in your cases?
Yeah.
Or an expert witness? I'll get back to that subject, but in any event, would you have found it useful if the judge had said, you can, as long as you were together in the same jury room, okay? You can talk about what you just heard or witnessed, but you're not to take a vote. You're not to decide the case. But you can talk about why they call that person. What was that all about? Or that person was a clear liar. Or that person's memory, something was wrong with that person's memory. Or, would you have found it helpful to you had you been allowed to do that?
I did.
You think you could resist the temptation not to decide the case? See, because what the judge is afraid of, or usually what the defendant is afraid of, is that you will decide the case before you hear the other side. And that's what the fear is. That's why you were told that. So if you're going to be allowed to do that, you have to be very careful. You think you can follow those kind of instructions, not to take a vote or anything like that.
Yes.
No.
No.
The jury that I was on, there's so many people that saw opinion, not actually listening to what was being said, your opinion began to soak in, even during our deliberation. And if we had that throughout the whole trial, that would have been a problem. Because there's sticking their opinions in.
To what extent, anyone can take this question who has a feeling about it, but to what extent do you think that the outcome was influenced a lot by the quality of the lawyer for either side. I mean, you know, the question is, the lawyers really make a difference, or is it the facts that count? Yes, Mr. Myers.
Well, I happen to serve with Mr. Kelly on the same case, so it's nice to see him here today. But to be honest with you, the plaintiff's counsel, she did a decent job, but she had a bad client, I would say, and the expert witnesses were not exactly the best. Having been an attorney and a cop, and been to many trials, I have to say that the last day, I wish I could have popcorn to watch the stuff, because the defense put on a tremendous amount of expert witnesses that were really relevant to the point, but he was so kind to the other side. He did liability. He said, hey, look, you know, if you want to do it from here, he more or less took us down this path, but he tried to cut off liability at a certain point. And I really appreciate what he was trying to do, because he knew it was a rear end case. And when push came to shove, I know some of the jurors were saying, well, we want to see this car accident. And in day two, I swear, and you know, I'm sure Mr. Kelly can tell you, I could barely see a scratch on it. But the woman, you know, you would think with a soft tissue injury was basically going to be crippled for life. But the plaintiff's counsel didn't really bring in the expert witnesses that I thought would have made the highlight for the case for, you know, the plaintiff. And whereas the defense counsel, and plus it helped the defendant, she was, I think, 8 or 9 months pregnant, you know, so I mean, there was that natural sympathy. But the defense counsel had expert witnesses that they blew me out of the water. In fact, I asked after the trial if I could just look, because I wanted to learn some new things about biometrics and what have you. And this doctor taught me about pain that I had never really understood. So from that perspective, it was really amazing to see what the expert witnesses did, the performance of the counsel. And the counsel, you know, this man was so magnanimous, saying, you know, if you feel for this person, you can do that. I mean, the defense really did a hell of a job. I really admired it.
You liked the lawyer and you respected the lawyer?
On both sides, yes, but especially the second one, the defense counsel.
Did the lawyers in your trials use many visuals, you know, like PowerPoint, slide presentations?
Yes.
Anything that you particularly liked or didn't like?
We had a lot of paperwork that we were supposed to be able to try to read on it, and that made it a little bit difficult, but they did point out to us what they wanted us to see.
So documents went on the screen.
Yes.
And how did they exhibit the documents? Were they just like a letter or something, or did they blow them out? You know, like a PowerPoint, you know, that blow up? What method did lawyers use?
Just the documents.
Just the documents. Anything that could be improved, you think?
Well, I'd like to back up to the one point about what happened in our trial was the prosecuting attorney gave us a lot of information that I felt wasn't really pertinent to the case. And I felt some of the times it kind of muddied the waters for what he was trying to prove. I don't think it actually changed the outcome, but during the case, it seemed to confuse us.
Yes, Ms. Hudson.
We were on the
Yes.
same, and I'm backing up too. I thought the plaintiff wasn't good.
The plaintiff, him or herself?
Yeah, he, and
Individual.
his wife was with him, because they gave different scenarios on what had happened. I'm like, if this is your wife, you guys should have And then at some point, I went along with the plaintiff lawyer, and then the defense would come, and he was so good, he would just make me forget about what the said. Make me understand that what he was saying didn't make sense.
Yeah, he had to clarify
Yeah.
the defense attorney.
So, in your case, did you get a plaintiff's verdict or a defense verdict? Defense verdict. And your case was defense verdict.
Split.
How did they split?
Well, we did 4 charges and
Oh, you had the criminal case. How about you, Mr. Schneider? That's right, and Mr. Myers?
Oh, the defense verdict.
That's right. Well, that's right. We have, so we have 2 juries represented like that. The defense verdict. So, you're also, anyone who's concerned that jury always favor the plaintiff should hear this, because clearly that's not what happened with you. I mean, you're a very, and yours was an automobile case, your medical malcase, or something. Yours was an automobile case. So, we have some, I met with a group of state judges in Hampshire County East, where I'm from. And they told me something that was just mind-boggling, and that is that in personal injury cases, automobile accident cases, or medical malpractice cases, the judge would have given more money than the jury did. Jurors were much more conservative giving money because, and part of it may be, I just don't know whether it's true or not. You know, there's been a lot of publicity in the last 30 years about how lawsuits are frivolous. And a lot of people will say that the word that goes with lawsuit is frivolous. You know, it's kind of a word association, frivolous litigation. I'm sure you can't live in this country and not be exposed to a lot of that kind of messaging. But it was interesting that it used to be everyone was fearful that juries would always rule for the plaintiff. And juries were much more liberal when giving damages to the plaintiff. But that seems to have changed a lot in this country. So we have here defense verdicts. During the trial itself, did the lawyers repeat themselves a lot? Was that a problem you had or not a problem? It's a short trial, so it may not have been a problem. Were the judges considerate of your time in the sense that you didn't have to sit in the jury room while a lot of other stuff was going on in the courtroom? Is that true in your case, Mr. Knapp? Yes, sir.
It seemed like we would take a 15-minute break, it would turn into a half an hour break.
Okay, that's enough.
It was an hour and a half. And then one day we had to stop early at 3 o'clock because of other things that had to be done. So a lot of downtime.
Well, one of the-
That I would have, you know, if I do something, I like to just keep right on going.
So let me tell you some things that are being suggested, and I'd like to get your reaction. One thing that's being suggested is the jury is entitled, as part of the juror's Bill of Rights, you are entitled to know when the trial will end. Okay, when you begin. It's a 3-day trial, you'll be out of here so-and-so. Or at least begin your deliberations. The case will be to you by Friday or Thursday, next Friday or Thursday. That's one thing. Another thing that the judge tell you specifically, we're going to take 15 minutes in the morning, 15 minutes break at a certain time in the afternoon, and lunch hour is going to be an hour, whatever the rules are, we're entitled to know it. And the judge has to adhere to the schedule. Nothing can come in. I mean, that's your right, because you're there and you aren't being paid that much money. Another thing that people have talked about is an alternate kind of trial schedule, where the trial goes from 8:30 in the morning to 2 in the afternoon. No lunch breaks. You have a short break, you stand up, short breaks for coffee, 15 minutes in the morning, 15 minutes early afternoon. But you're done every day by time certain. So you, business people, I guess none of you had that kind of schedule. It was a regular schedule. Would you have liked to have some different schedule or not? Or was it fine just to have a regular schedule? You're fine with a regular schedule. And again, I'm talking to people who did a short trial. When you went the instructions, were they understanding?
Yes.
When you went to deliberate, back in the jury room to deliberate, was anyone informed? You were informed. How did you get to be informed? How did you get to be informed? I mean, did you campaign for it? Did the judge appoint you? How did you get to be informed?
Well, I guess it's because I talked to most of the people what were during the jury. Went to lunch with a couple, I talked about the trial, but I went to lunch with them. And I got to know the people. And I was not really vocal. We had a couple that were pretty vocal and they wanted to be. But I guess you just didn't know the people that were on the jury with me. They decided I was the most confident one.
Did you have, during the deliberations, did you have any questions you sent out to the judge?
Oh, yes.
So the answer is yes.
Oh,
The
yeah.
first sheet had 9 questions.
Oh,
Okay.
yes.
Now that you've identified it.
I'm sorry.
Well, I should have known that the reason you all are here is probably one of the judges got you to come. We asked them to get jurors to come, and they come to it, that's fine, okay? But it usually works out fine because it's usually a mutual admiration club. And this, what I've done about juries, and doing this around the country, is the jurors love the judges who presided over their trial. And the judges, and there's a close relationship. And, you know, people are, I've had judges call people who were there 2 years ago and get them to come to one of these lunches. Now, they don't remember much about anything except they didn't like the cookies. But y'all have done this fairly recently, so you're pretty good at it. So when the questions were sent out to the judge, was he able to respond to your satisfaction or not?
No.
He was not. Okay, that's fair. What did he tell you back? What did he say back?
You only use what was presented at the trial. Use your notes. We sent 2 or 3 times to him, and finally, after the third one came back to us, we decided we don't need to say anything else to the judge.
Okay, that's a fair comment. And one thing I heard yesterday from 2 of the jurors, I never heard of these ones before, never even thought about it before, was that they felt during the deliberations they were pressured to return a verdict. In other words, they were operating, you know, the other jurors, let's get out of here. We got to get out of here. That both the judge and other jurors put pressure on that to reach a verdict. And they were kind of upset with the way it worked because they didn't feel that they were fully heard. Any of you had that experience?
Yep.
Yeah, okay. So what was that experience?
Well, we had a couple people on our jury that, you know, it was getting close to after 5 o'clock. They, come on, let's give, you know, we had a couple that were pretty vocal. And I was the type that I would say, let's stay till we get it done, you know. But we had a few that were trying to, we had a couple that were going different ways. They were trying to say, do it now so we get out of here. I wouldn't let them do that, so.
Okay, you protected.
I protected,
The other
everybody had
jurors.
a right to their own vote and their own decision. They had a right to speak up. When you got somebody that's on your jury that is loud and vocal, some of your quiet ones won't speak up. So whoever's your foreman's got to go around and basically sell the loud one down. So that everybody, because you have to listen to everybody's opinion.
Mr. Byers, how long did it take for your jury to reach a verdict?
I would say 30 seconds.
Literally, we stretched it to 15 minutes.
You know, now, of course, you're giving credence to the fact that some lawsuits are. I think some of you pointed out in your questionnaire that you filled out that it was kind of a waste of your time to do. How long did it take you, Ms. Hudson?
2 to 3 hours, and what I was surprised because we weren't allowed to talk, and I was surprised how many of us were on the same page once we got in the room and started looking. So we worked through our lunch break, and so we could complete it. So 2 to 3 hours.
All right. At the end of the trial, you turn your verdict. Did the judge allow the lawyers to speak to you?
Yes, and that was great. He also came
He came to you too. And where did that speaking take place? In the courtroom or the jury? Where did it take place?
in the jury room.
In the jury room. Did lawyers on both sides come talk to you?
Yes,
Did you feel comfortable doing that?
yes,
Talking to them?
yes.
And how about Mr. Kelly?
The judge came back to our jury room, but over half the jury had already left because it was like 7 o'clock at night. And then the attorneys, I know I went out and I know Sean was out there too. We talked with the attorneys afterwards out in the actual courtroom.
Okay. Schleifen.
Judge and attorney both came back into the room and they talked to us.
Mr. Schnack, your case, you were discharged before you deliberated. Case 7?
Yes.
Case 7. Okay, now you probably can talk more freely than anyone else here. By the way, lawyers and judges, what we are looking for in all these communities for a great program is to find a complex civil case that lasts about a week or more, that settles after the verdict is returned. Because then we can contact all the lawyers on both sides, all the jurors, and the judge, and put on a program that will knock our eyes out. I mean, those are great programs because everyone can talk freely. There's no post-verdict motions or anything. You put it out there the way it is, and that would be great. But in your case, since you were discharged, was it almost at the end?
No, it's halfway through. I think the plaintiff had got his, plaintiff's attorney had finished, the defense hadn't started, and it was after the trial that the judge came in, talked to us, and then the defense attorneys came in. So I'm assuming the defense came out on top in that settlement.
Okay. And did you talk to other jurors about how they would have voted based on what they had heard thus far?
I didn't specifically talk to them, but they're, in the question and answer with the attorneys, I kind of felt like everybody was swaying towards the defense. Myself included, and I work for an insurance company, and they were an insurance company.
Let me go down. Let me go down the line and kind of get you're talking about the lawyers and judges who are here because they want to make things better. They came here, you know, we all do it for a living, but when you do it for a living, sometimes you don't see the forest for the tree. What could you tell us? Shank, I'm going to go down the line. What could you tell us we should do different to improve the system? Don't mention cookies and
I had a very comfortable experience. I was looking forward to it, and I'm generally a glass half full kind of guy, so
okay.
I expected there to be a lot of hurry up and wait, and there was some of that, but I was okay with it.
Fair enough. Mr. Meyer?
Well, you know, the tax lawyer in me says that instead of giving cash to the people, you know, cash is difficult. I know we use tax policy to have people get married, have children. Why not give maybe a tax deduction, say $500 a day? I'm just kind of a round number to jurors for each day of service that would be signed off by the jury commissioner, and give it to the jurors, you know, to write off on their taxes. I think that it's a virtually no-cost benefit provided by government, and at the same time allow those jurors to get some sort of hidden compensation that they wouldn't otherwise have.
Great idea. Great idea. You're talking, you know, the interesting thing to me is that serving as a juror is the only thing our government demands of you under the Constitution. But yes, you have to pay taxes, but that's a statutory thing. But being a juror is a constitutional duty you have. And no longer do you have to fight war. It's voluntary. You don't have to vote, you know, except when you are a juror. You have to vote. And so it is a demand we make of people. Now, none of you serve normally around the country. People think more than 5 days is a hardship on most jurors. So a short trial like you went on, we're not going to. When it goes over with the week 2 and week 3 or 1 week, should be some facility for compensating the jury. How much did you make a day here? Franklin County, what is it? $20 a day. $20 a day. Parking was more than that, one of the jurors said.
I did $10. I parked close to the courthouse.
You netted 10. Mr. Lightfoot.
Judges and jurors, I learned a lot. The only question I had at the beginning when it started is there were 105 people on the jury pool. There was nobody younger than 35. Why? I mean, 50% of the people there were retired. I I would say at least 50%. Does not make sense to me how you can have 105 people picked for a jury pool and nobody under 35 years old.
Judge Fry, you have an explanation for that?
Blame on the computer.
Well, and that's what he did in our courtroom too. We had no minorities in our courtroom. We had only 5 minorities and our 105 people picked. Why?
I suspect no-shows probably were on the younger end, maybe, but that's a guess. I don't know.
Mr. Kelly?
Well, I guess the concern that I heard, the issue that I had was, and I know you said the jury trials are dropping down and everything, but I still don't understand how the trial we were on got to that point. How, like I said, we decided in 15 seconds the verdict. How could they not see that up front and still want to take a case like that to a trial and spend everybody's time and money when it was apparent what the verdict was going to be? I don't know what they expected to gain out of it.
Well, Prof, it was a personal injury case. Right? So the lawyer had on a contingent fee. Some lawyers are really bad. I mean, they really do not understand that a third of nothing is nothing. That's a problem, but that's bad. They're bad lawyers just like they're bad in every profession. And some lawyer made a horrible mistake and he cost him or her some money. Ms. Hudson.
I think our case was similar, because I didn't see why the person that was found in the complaint would be denied. Because I thought they offered him everything, kitchen sink.
I come in here trying to persuade the judges to do more jury trials, and the jurors are persuaded to grant more summary judgment. I obviously on the wrong side of this. Ms. Hartley?
I thought the plaintiff attorney, I was surprised that he took the case, because when all the facts were presented, it really leaned toward the defendant. It didn't bode well, I thought, for the plaintiff. And then the fact that he muddied the waters with information we didn't really need, that just confused things further.
So let me ask you this. Particularly the 4 of you that were in what you was a close to perfect case. Suppose there's a procedure called summary jury trial, where the judge assembles a jury like the 6 of you, for example. But you're not a real jury because your decision is not binding. Each lawyer comes in and is given an hour to make his argument to you. The best he can do. Show you documents, tell you what the testimony is going to be, and then you go and deliberate. And then the parties have seen how it's going to come out. And maybe they don't, you spend an hour or 2 hours in that exercise rather than having people have to spend 3 days in the exercise. Would you feel it was unfair to you? You don't have a constitutional duty to do that. Okay? But it sure would be helpful. Would you be willing to have done that where the judge tells you, this is not like, we want to tell these lawyers, give them an idea of how this is going to come out, and their clients live. Would you be willing to participate in that kind of exercise?
Yes.
That might save someone a lot of misery if you tell people in advance. So that's another thing. Does anyone here have any questions you want to put to these jurors? If not, thank you very much for coming. Yes, go ahead.
I'm just curious for each of you, when was it during the course of the presentation of the evidence and testimony that you feel like you've made up your mind?
Can you repeat? I can.
Yeah, I'm sorry. When was it for each of you during the presentation of the evidence and testimony that you feel like, okay, now my mind's pretty well made up?
I'm not going to let him ask you that question. Because I don't think that's exactly, but here's what the question is. A lot of trial advocates, young lawyers are taught that that your opening statement is the most important thing. The teachers, what they call primacy, is the most important thing. What you hear first is very important. So, I guess in general,
did you think, by the time the plaintiff, did anyone think they made up their mind during the opening statement? Not really. You kind of don't know who to believe in, right? You're just looking at judges. I mean, just looking at lawyers. So much more eloquent than not everybody you're looking at. Then the evidence begins coming in. By the time the defendants begin, I guess people have a pretty good idea. Some idea, right?
Yeah. Yes.
But, so were you most of you able to keep an open mind till the end?
I think I was very close to the end before I.
You were actually close to the end. Okay. Any other questions? Thank you very much for coming, and you'll take a survey and let us know. We'll decide what to do. Thank you very much. Thank you. All right.